Well, good morning to all of you from Autopaychecks here. First of all, our team at Autopaychecks would like to thank all of you for taking the time to attend today's discussion. We recognize that you are very busy and your time is precious. We will try to make this time as valuable as possible. So I want to offer a special thank you and introduction to Mr. Michael Santo here from Bechtel, Santo, and Severin. Michael is a local labor attorney here in Grand Junction who we have a fantastic relationship with. Michael, in his law practice, specializes in supporting and defending employers in employment litigation since 1994. Today, Michael will be discussing the changes to the employment law as it relates to COVID-19. As you know, this has come on all of us very rapidly, and many of the final details as to how these new regulations will be applied are still being argued in Congress. We will do our best to keep you updated as this unfolds. Michael's contact information and that of his firm is on the screen now, and you will see it again, and you can reach out to him directly if you need help. We have 60 minutes scheduled for this meeting, and we will have a hard stop at 12 p.m. Mountain Time. All attendees will be muted during the presentation so that we can get through the information that has been developed. There were over 260 attendees signed up, so it will be impossible to have an open discussion. We'd like to ask you to please send any questions you have through the open chat feature on your screen, and we will try to address as many of those during the allotted time as we can. We will also be sending the slide deck out to attendees for your review, and thank you for attending. We really appreciate your time. Many of you are not necessarily our clients, but are related to partners of us in the community, and we thank you for being here. I'm going to turn this over to Michael and not waste any more of your time with my discussion. Mr. Michael Santo.
Thank you. Trying to make sure I don't hang up the phone. Okay, good morning, everyone. Certainly, as John mentioned, this is a constantly developing situation. We tried to put together as much materials as we could in the short period of time we all had available to us to make sure we got it to you as soon as possible. I was giving a short talk on this on Friday and was telling everybody on the Friday talk that I expected the Tuesday talk to be entirely different information, just simply based upon how quickly everything's developing. So let's start the talk right away. What are we going to cover today? Well, we're initially going to cover the federal and state measures enacted in response to COVID-19, the various leaves that are available, the various funding sources that the government is trying to get out there with respect to certain issues, current laws and their application. Oop, I already see a typo. I was just mentioning to John before the talk that these materials were put together so quickly that I expected to see a typo or two now that they're actually being presented to this larger group. And there it is on the first slide, so what do you know? In other issues, so one of the things that was mentioned in the agenda was that we were going to cover a brief background. As I often joke with folks, I missed the day in law school where they taught medicine, so this information regarding the medical is information that I've asked others to help me with, but it's going to be very, very basic, which is initially this was first emerged in December 2019. The typical symptoms that are associated with COVID-19 are principally cough, fever, shortness of breath. One thing that everyone needs to keep in mind, of course, with respect to it, and we'll get into these questions near the end in terms of what can we do to test our employees, to make sure our employees are healthy, those kind of things. One thing to keep in mind is not everybody with these symptoms necessarily has coronavirus. I would say as a current allergy sufferer, you're probably going to hear me sneeze and cough sometimes during this, but that's due to the fact that I'm now going through my spring allergies that I do every year. These are very similar to flu-like symptoms. Back to the initial on COVID-19, not only everyone who has these symptoms will not necessarily have the coronavirus. Similarly, those who are positive for COVID-19 necessarily may not exhibit any of these symptoms, or may exhibit these symptoms in only a small, only have small symptoms. Of course, the symptoms can be very severe. We've seen the numbers across the board, seen the numbers coming out of Italy. and it can be passed person to person. Currently, I just saw numbers come up that today we're probably going to pass worldwide 400,000 positive tests and 50,000 positive tests just in the United States. Currently, of course, as we all know, there is no vaccine for this, and symptoms tend to show up within 14 days of exposure. So how does one protect themselves from the coronavirus, from COVID-19? As I say here, hand washing, and don't touch your face or someone else's face. Keep coughing etiquette and social distancing really are the keys to this, making sure we're complying with the Center for Disease Control, CDC's information on this. They are producing near-hour information in terms of how to best address this issue. But those are the three main things they're focused on, particularly social distancing. As of last night in Colorado, we had 720 positive cases. We are one of the leading states right now in the country in terms of the number of positive cases, and seem to be going up quite frequently. Unfortunately, currently the way it's worldwide is there a 4% mortality rate. Ongoing efforts are being undertaken to improve treatment, therapy, and of course, as we've seen before, the phrase that has entered all of our lexicon is flattening the curve. So that's just a little bit of basic on the COVID-19. As I said, I have almost no medical knowledge, so I appreciate those who were able to help me with that. Last Wednesday, well, basically this started last Saturday, about 10 days ago, the House of Representatives, with the current administration's help, came up with 2 leaves and a number of other measures that we're going to talk about from the beginning, in particular the paid leave, a modification to the Family Medical Leave Act, and the additional sick leave protections. Those were passed by the Senate on Wednesday and signed by the President Wednesday night. Let's start with the basics, because if we go back and we see paid job protected leave under the Family Medical Leave Act, a lot of organizations with under 50 employees may think, okay, well, this doesn't cover me. In fact, it does. The way the law is going to read, there will be an amendment to the Family Medical Leave Act that until December 31st, and it may be extended longer, of course, depending on how much that curve gets flattened, employees of employers with less than 500 employees have the right to take up to 12 weeks of job protected leave. That is a modification to the FMLA. Normally under the FMLA, it is 50 or more employees. So this is a change to that. Those with over 500, if you have 501 employees, you are not covered by this requirement. You do not need to enact these leaves. You do not need to provide these leaves. Certainly, of course, you can, you're just not required to. What's interesting is that the leaves are so broad as they were set up under this House Resolution 6021 that it covers independent contractors and self-employed individuals who can also get these benefits in the form of tax credits. So this is unusual in that both independent contractors and self-employed are usually not eligible under the FMLA, but in this situation, they can be. As I said, who is not covered? Well, it starts with 500 or more employees. They are specifically exempted from the requirements. The reason why the House said they did that, the House of Representatives for the United States said that they did that, is they believe that most organizations with 500 or more employees already provided these leaves, and so they did not think that they needed to have them provide double the leaves. So it just covers those with 500 and under. Additionally, those healthcare providers like hospitals and nursing homes, emergency responders can elect to exclude. In essence, if you have under 500 employees and you are one of those groups, you could provide it, but you're not required to. The big issue that we get a lot of times, particularly from smaller organizations, those with 50 or under, is that there was some language in the law that the Secretary of Labor, I should say the Department of Labor Secretary, is going to issue regulations. The last time I saw that date, they were anticipating those would be completed on April 3rd, so the day after all these leaves go into effect. The Secretary of Labor was going to produce regulations. One of the regulations that the Secretary of Labor is enacted to identify is what exactly it means to exempt certain healthcare providers and what it means to exempt emergency providers. The big one, though, that frankly I'm anxious to see is what the Secretary of Labor is also authorized to produce regulations with respect to this phrase of employees with small businesses with less than 50 employees, if such leave jeopardizes the viability of the business. At this time, there's no guidance in the law for what constitutes a jeopardy for a small business owner. We are anticipating, and I expect it will be in the Department of Labor's announcements. I mentioned later in this presentation that the poster that Department of Labor is producing is supposed to be completed by tomorrow. I looked this morning, hadn't seen it yet. It's supposed to be produced by tomorrow. There's a chance that perhaps in anticipation of addressing it in their regulations, that the Department of Labor addresses the issue of jeopardizing the viability of a small business in that poster. I wouldn't think so, but certainly for those organizations with 50 or under employees, I would be monitoring what that poster says to see if we get any information as to how that is going to be defined in the regulations coming out. So what is the leave? Well, what employees are able to do is take 12 weeks of paid leave because the employee must care for their child under the age of 18 if the child's school or place of care has closed. I think in Colorado, at least as far as I know, pretty much everyone's school is closed. I believe most place of cares have closed. And it also has something for if the child care is not available. So if you have an employee who is unable to work because the employee has to take care of their child or can't perform telework, that employee is entitled to 12 weeks of leave under this new FMLA regulation change. Yes?
Dawn asks, how does this apply to agricultural employees?
Right now, I haven't seen any exemption for agricultural employees. I'm seeing the way the law defined it, it was across the board, 500 or less employees, you're covered. The only exemptions I saw were for healthcare providers and first responders. I think that's going to be a fairly consistent theme. And things that come out is that healthcare providers and first responders are going to be exempted because of the necessity for those positions. So right now, I have not seen a exemption for agriculture or any other specific businesses. You may see others in the future. The regulations may identify that, but as of right now, the law does not. Yes?
Okay, one more question. So many of those attendees here are under 50 employees and have not been under FMLA before this point. So can you walk through just a little bit?
Oh yeah, good question.
What has to be paid under FMLA and because that's going to be different than this, than the COVID emergency sick leave.
It's a great question. I hadn't thought to address that issue. Yes, the Family Medical Leave Act has been around since 1993. It covers organizations with 50 or more employees and requires those organizations to provide leave, unpaid leave, to employees who have a serious health condition, or if they're needed to care for their child with a serious health condition, their spouse with a serious health condition, or their parent with a serious health condition. The main requirements under the law for unpaid FMLA that has been in effect since 1993 is their job is protected. So when they're out on leave, we can't give away their job. We can't they have to come back into basically the same or equivalent type of position as when they left. Additionally, we have to continue on their health insurance benefits. Both those will remain under this modified FMLA, but that is unpaid leave and is up to 12 work weeks. So this is different than that one.
Thank you.
Sure. I want to make sure that was a 3-hour FMLA talk compressed down to about 30 seconds. So the first 12 weeks are paid leave. We'll talk in a second about how the pay needs to be calculated. But the first 10 days of that leave are going to be unpaid unless the employee chooses to use their accrued vacation, accrued personal leave, accrued PTO, CAL, EI, whatever you may have as your organization. The employee can choose to cover those first 10 days with those leaves. The employer, we cannot say, hey, employee, you have to use this leave ahead of time. Additionally, if an employee has the eligibility to take this leave, so they are unable to work because they must care for their child, we cannot double dip, so we can't use PTO at the same time, or we can't use sick. This leave is unlike FMLA, the way it has operated since 1993, where you could use paid leave at the same time you're using FMLA. We, under this new FMLA, or offshoot to the FMLA, we do not have the ability to double dip those.
This is paid or unpaid?
This is paid.
Okay.
Paid. If I said unpaid, I apologize. The first 10 days are unpaid.
Right.
But thereafter, it's paid. And we're going to talk in a second about how employees can also, they'll have access to other leave that will pay that 10 days. After the first 10 days, employees are going to be paid for the next 10 weeks at 2/3 of their pay. It's going to be capped at $200 a day, $10,000 total. If you have an employee who is currently on your payroll, they are eligible for this after 30 days. So it does not have the same requirement as the FMLA currently, which is 1 year of employment, 1,250 hours in the past year. It is basically, if you've been employed for 30 days, you're covered by this. Those employees who are furloughed, those employees who are working half schedule, those employees who are working at all are subject to this leave. If they've been laid off, they're not subject to those leaves because they're no longer your employee. The question that I get a lot of times is, what do I do if we're shut down and I still have a lot of employees who are technically on our payroll, technically still an employee? Are they eligible for leave even though they're not working? That's a very good question. I would anticipate that the answer to that question would be yes. I will be anxious to see what the Secretary for the Department of Labor issues in the regulations, but my anticipation would be if you've got an employee, they're eligible for leave. So the next question goes into, what do we do with part-time employees? Basically, those who work in a regular schedule, they receive pay based upon the average number of hours worked for the 6 months prior to leave. If they have not worked 6 months, that is basically to the reasonable expectation of the leave. So, and then finally, as soon as practicable employees must provide notice of the leave to employers. That is going to be the requirement. So this is a big expansion of the leave, and it is being designed, I think, intentionally to find a way to get compensation to individuals who are not able to work because they're home taking care of their kids. To cover the cost of providing paid FMLA, and I'm not a tax attorney, but this is the exact quote, the Act provides employers a credit against the employer portion of Social Security and a refund if the FMLA amount turns out to be more than the employer's Social Security bill. I get asked all the time, well, is it better than to place them on unemployment, take this available, how does it work out tax-wise? I frankly do not know the answer to that question. Something certainly you'll want to talk to your tax advisor, payroll company, talk to Autopaychecks about, but we do, I have not run the numbers on that.
We have one point of clarification.
Sure.
If a furloughed employee is not entitled to this, is that correct?
Is a furloughed, it depends, I'm gonna cheat and use if I were doing a talk right now, I would give away a handout or a mug or something as the first question that allowed me to use my answer of it depends. It depends on how you define furloughed. A lot of organizations define furloughed employees as you're still employed with the organization, you're still ours, but for example, we're only now working Tuesdays and Thursdays, or we're only furloughed to the point of we're taking off Fridays, or we're taking off mornings, or we're doing something like that. If they're currently an employee, the way the law currently reads is very expansive, and current employees are eligible for this. If you're not an employee, you're not eligible. So if you're by furloughed, you mean they're no longer employed by the organization, then they would not. If by furlough you mean, well, they're still with us, but they're kind of not sort of working as much anymore, or maybe they're working from home half-time, or maybe they're working from home some of the time whenever they can, that's still an employee, and they will be eligible for that leave. Got it? Okay.
So I've got a point of clarification. So some portions of FMLA are unpaid leave and some of them are paid. So can you address that here? So you talked about FMLA and how it relates to this, and we've got 12 weeks of paid leave or not paid leave, paid without pay. How does that work?
So the standard FMLA is unpaid, which is covering serious health conditions. This leave is paid. The law did not address, I assume the regulations will address, there are times in the law under even unpaid FMLA where, for example, if you have a husband and wife both working for the organization, you can tack their 2 leaves for birth or care of a child, so they only get a combined 12 weeks. The question, by your question, the question that the regulations need to identify is, if, for example, an employee uses this, let's call it child out of school leave, and that counts as 12 weeks, and they use those 12 weeks, do they then get 12 weeks of unpaid FMLA after that for their, let's say their child develops a serious health condition, or they develop a serious health condition? Are those separate leaves under the law? It would be a guess on my part because the law does not identify it. The regulations will. I would expect that the regulations would probably lean toward allowing employees then to get 12 weeks of unpaid leave for the serious health condition. So it would be 12 weeks of paid leave, actually 2 weeks of unpaid, 10 weeks of paid, then 12 weeks of unpaid for a serious health condition. I think that's going to be the case, but the way this is developing, we won't know until April 3rd. I think you could certainly see these extended when that 12 weeks runs up. So that's another issue as well.
Another question from Bob. If hours are reduced, must we still go with the full-time hours as an average during the last 6 months?
Yeah, that's a great question, Bob, in terms of how we determine those hours. Pulled from the law, they look at the last 6 months actually worked, even though it may be reduced. Now, the DOL, at least in the law, was not given the charge to come up with regulations with respect to that calculation. I think they will come up with it with respect to part-time, but I expect that the law will continue on that. If they've been working 40 hours, even if they maybe have been reduced to 20, that it would still continue to 40, or maybe if they've been reduced entirely. If you have an employee who is working, for example, though, 20 hours, you wouldn't need to provide them leave for that 20 hours. They would only need the leave to care for the child. Maybe they have a spouse who's taking care of the child for the other 20 hours. Then they would be taking the leave for those 20 hours. they would be eligible for that 20 hours of leave. Upon return from work, they had to be restored to their same or equivalent position. What's interesting is they did make an exception for those of us with under 25 employees that said that they do not have to restore the employee as long as certain conditions are met. And the main condition that's met is the employee's position is no longer available. In that situation, that you don't need to restore the employee, but we at least have to make a reasonable effort to restore the employee to an equivalent position for up to 1 year. That is what we currently know under the child care leave. As I said, it's all from the law. Oops, not there. Let's flip now to the next leave, which is the 14 days of sick leave. Same requirements, same coverage, I mean. Those employees who work at organizations with less than 500 employees and at governmental employees are entitled to 80 hours of sick leave. So initially, 80 hours come April 2nd, 2020. If you're in an organization with 500 employees or less, you have to create a leave bank, and those employees are eligible for 80 hours of leave. As you see in the slide there, part-time workers are also covered. Who is not covered? Those organizations with 500 or more employees are not covered. Similar to the child care leave, certain healthcare providers and perhaps those with under 50 employees may not be covered. We will wait until April 3rd to see what the Department of Labor Secretary says. Initially, I put this up here. This is from the IRS. I feel like they were trying to jump the curve, so to speak. They put out their own information and said that the exemption will be available on the basis of simple and clear criteria that make it available in circumstances involving the jeopardy of the viability of the employer's business as a growing concern. So I thought it was nice that the IRS was telling the Department of Labor that they expected these guidelines to be very clear and understandable. So, a covered employee, as I said, may take up to 80 hours of sick. These are broken out into 5 reasons, and you will have access to these materials after the talk. These reasons need to be, when you get a reason and someone missing, look, because it's going to determine how much they're entitled to and what their maximum is. So for example, the first one is an employee is subject to a federal, state, or local quarantine or told by a healthcare provider that they need to self-quarantine due to COVID-19. That has to be paid, the 80 hours has to be paid at 100%, capped at $511 a day, capped at $5,110. The key language in there is employee is subject to a federal, state, or local quarantine. We may see at some point, we're certainly seeing counties come up with quarantines. California has come up with one. Perhaps Colorado will. If that occurs, then depending on the language of what the quarantine is, simply the last time I looked at New York was just a recommendation. What happened there? New York was just a recommendation. That would be a quarantine. But if we are under Colorado, a self-quarantine, they would be entitled to 100% of the pay, capped at $5,000.
So, clarification. So if an employee, say, has a sick family member and they can work from home, they can telecommute, or they can telework based on this language, then you don't, just because they're at home, if they can work from home effectively, you don't have to pay sick leave just because they're not in the office.
You wouldn't have to pay child care if they could telecommute from home.
Right.
The sick leave is going to depend, similarly, are they missing time because they're engaged in one of these 5 things?
Okay.
So if they're, let's go back to this one. If they're, what did I do? 1 second. If they're subject to a quarantine, but yet they're still working, the argument, of course, would be they don't get that 80 hours because they're still working.
Terry asked, can you please confirm firms under 50 employees still have to pay this out to the staff?
As of right now, the answer, Terry, to that is yes. You still have to pay this out to the staff. As I said, we're waiting April 3rd when the DOL releases their regulations. If you can claim that your business would go under to pay this, there would be an opportunity not to. But until December 3rd, till April 3rd, we would not know that. If you're seeking medical diagnosis, that's paid at 100%. This is a key one. The employee is caring for an individual who must self-quarantine for the same reasons. That's paid at 2/3, capped at $200 a day, $2,000 total. Keep track that says individual, not family member. This is an expansion to the FMLA, so they can be taking care of their friends for COVID-19 symptoms and would be covered under this. It's not simply under the FMLA, it's very specific, family members, kids, significant common law spouse or their spouse or parent. This is any individual. If they're caring for someone under 19, if the child's school is unavailable due to COVID-19, this is paid out at 2/3. So when we were talking about that first 10 days is unpaid, it's really not unpaid since this is one of those criteria that's covered. And the employee is experiencing any other similar condition specified substantially similar to COVID-19. So if they have a cough, if they have high fever, if they're having trouble breathing, they would be entitled to this 80 hours for that. Part-time employees, we've talked about this before, look toward their normal schedule. Oh, if requested by the employee must pay a full-time employee for 80 hours instead of the initial 10 days under that. Based upon the 5 scenarios, employees do not have to have the coronavirus. This is clear in there. You don't necessarily have to have tested positive to access this leave. So not all employees will be able to get a doctor's note, but they're still going to be able to get this sick leave if any of those 5 scenarios apply. And I already talked about individuals. They put this in there that we cannot require the employee to find coverage for them. And similar to the child care leave, there is the same tax credit leave under the sick leave. In short, with both of these, keep track of hours paid under this. Is it going to be determined to be quarterly that you can get those payments back? Is it going to be yearly? Whatever it is, there will be tax credits available. So make sure we're keeping a very good track of what hours you're paying out for. We must post notice informing employees of the leave by as soon as possible, which will be March 25th. The Act does say, or the law says, in a conspicuous place. Of course, with so many of us working from home, that may not be very practical to get the information to them. So please consider emailing the notice out to all employees when it's made available. This is in addition to anything you've already given. So we are not allowed at this point to take back leave given. If you have an employee with 300 sick leave hours built up, we cannot reduce that. We cannot change that. There's been a lot of organizations' policies may say we're able to pull sick leave back because it's treated differently than vacation leave. That I think would be inconsistent with this current law. Federal law would trump that and say, no, you can't pull sick leave back, you can't take away. They must have access to their full leave. And employers cannot require employees to use other paid leave before using this sick leave. They have to be able to use this one first. It says currently that it will not carry over to 2021. I think we can all foresee if the curve is flattened long enough that requirement may go away, but at least what they're saying is it cannot carry over beyond this year. And similarly, if an employee leaves, they do not have to be paid that upon termination, like, for example, vacation leave. But again, we're waiting for April 3rd. Yes?
Question, where does workers' comp fit in if we are a healthcare provider and the exposure happens at work?
So this is frankly a very interesting question. I've been told from, I can't tell who told me it from workers' comp, but they're looking at this as a, as a non-covered workers' comp event, so to speak, that even if you have someone who tested positive for COVID-19, the workers' comp will at least initially take the position. Obviously, there's been no cases filed, there's been no anything filed, but they will initially take the position that it is not a work-related injury, just because of the nature of the transmission of this and for a lot of other reasons as well. So certainly if you have an employee say, hey, I contracted this at work, I would reach out to your workers' comp provider simply because that is always my mantra. Always call workers' comp with respect to any injury that may be at work, simply because you don't want to lose that coverage, which you can do if you don't notify workers' comp. But I have a feeling, at least what I've been told from the folks I've spoken to at Pinnacle, they're going to treat this as a non-workers' comp event, that maybe, perhaps it was just the individual I spoke to that said that, but at least I think that I would expect that that would be their position. It would frankly be a lot like the flu, where they would say, who knows where the flu comes from, we're not going to address that.
We have some questions coming in about firing employees. Is that able to be done at this time? What kind of benefits are provided?
You can, of course, terminate any employee. Colorado remains an at-will state. So the old expression, the old mantra under at-will, we can terminate for no reason. We can terminate for any reason as long as it's not unlawful. The concern here would be if you said, for example, well, Bob or Mary, I'm letting you go because I don't want to pay this paid leave. I would facetiously say we need to work on your deposition testimony. That would be something I would stay away from. I would not make any employment decision based on this leave being provided to employees. Now, that being said, if your business shuts down and you're laying off employees, eliminating position, that you're certainly able to do. We want the impetus for the adverse action to be those kind of issues, or perhaps it's a performance issue, perhaps it's an attendance issue, whatever it may be, it's just not being driven by this law. To the extent that we're saying, well, I just don't want to pay you 12 weeks of leave, there are retaliation provisions under both of these provisions. So organizations who simply do it because they don't want to pay for those paid leaves may want to rethink how they identify the basis for their leave, for their terminations.
So if the business is closing because they just don't,
no revenue.
They have no revenue.
Yep.
Then it's still, you say, look, we don't have any revenue, we can't pay you, we're limited in these positions.
Yeah.
That's a viable answer.
You can certainly do that. I saw a publication, I forget which publication it was, that was trying to figure out exactly why they picked April 2nd for the date where that was going to happen. It's an odd date, it's a Thursday, it's not the first of a month, there's a whole bunch of other things, but the publication opined that perhaps they were doing that to allow smaller organizations to keep people on health insurance on April 1st, and then say, well, the business is closing, so we're going to cover your health insurance for April, but come April 2nd, we're not going to be in business anymore. I think that's a big speculation, but I guess that could be the reason. But yeah, you can still terminate employees. If your business is shut down, you're not operating that, or you're eliminating positions, you can still do that. You just don't want to do it because of these two leaves.
And if you terminate those employees, is there any continuing obligation to pay out these leaves?
Not those leaves, not that I've seen.
Okay.
Not the way the law reads. It would be a real stretch for the DOL regulations to cover non-employees or recently terminated employees. They will have substantial protections for retaliation for employees who may use the leave, but I don't, I'm not inside the mind of the Secretary of the Department of Labor. Could they do something for those recently terminated? I guess it's possible, but that's not the way most employment, I've never seen an employment law that covers it, but it could.
We're getting a lot of questions about job attached unemployment and an actual start date for when this these benefits take place, what if somebody is already in quarantine?
Right. So let me take the job attached, I'll get to in a second, because we are gonna go over some unemployment things. If they're on job attached, they are laid off, they are, I was gonna do job attached. The benefits start April 2, they don't start before April 2. So if you have an employee that's quarantined now, they technically, under the law, are not eligible for these benefits. Could you, quote-unquote, cash advance the benefits? I don't think that would be, yes, it puts them in the same place, so that would be the argument, but yeah, I would be reluctant to do that because it's not into effect. You can certainly do that with employees in terms of you can cash advance PTO benefits, you can negative accrual, vacation leave, and those kind of things. I would encourage organizations that do that to make sure you're getting a signed agreement to be able to get that back from the employee should they not return to work or those kind of issues. But if you want to do that, the leave for these don't start until April 2nd. Someone sent in an email question, did I see any hope of it starting before April 2nd? I don't think so. This is really quickly to have this implemented within basically 2 weeks. So I don't think that will be the case. Job attached is next. Let me get to federal unemployment, which is basically, there's a portion of the act that is throwing a whole bunch of money into our state unemployment right now. I'm not going to go into issue on that because it's just frankly that we're trying to fund those programs. A question I get quite frequently is, what do I do with that employee who doesn't want to work because they're worried about an unsafe work condition? And are they eligible for leave? Are they eligible for benefits if they quit because they don't want to work, or if I lay them off because they're refusing to work? How does that get handled? Initially I'd say this is just for your benefit. I really discourage organizations from providing legal advice to employees about their ability to access unemployment benefits. I've seen weird things happen in unemployment benefits in terms of employees who are laid off not receiving unemployment benefits. Don't ask me how, but they didn't. Or employees who just quit because they wanted to receiving employment benefits. So you never know with unemployment which way they're going to go. But for your background, unemployment does provide for employees to quit when they believe that the employee is subjected to a hazardous working condition. And I've got that developed. The degree of risk looks at health, safety, and that what hazardous working conditions mean. Where is it? Limited consideration of safety measures used, lack thereof, a condition of equipment, proper equipment, those kind of issues. Of course, no work environment is going to be completely, hazard-free. But what they're looking at is that the bottom language is no work shall be considered hazardous if the working conditions surrounding employment are the same as those working in general prevailing among workers. That would seem to lead to this may not be covered under unemployment, but until those claims start getting filed, I would not opine as to that. But for organizations, we're getting a lot of questions in terms of, will the employee be eligible? My response is let's let unemployment figure that out, but that is an issue under unemployment for unsafe working conditions. Don't forget that employees who work a reduced schedule, who drop below 32 hours, may be eligible for partial unemployment benefits. So they can earn up to 25% of their weekly benefit amount if they drop under 32. So those organizations who are thinking of, let's say, taking their 40-hour employees to 20 hours, they'll be eligible for those lost hours under partial unemployment. So something to keep track of as well, that employees may be filing, or you can recommend employees can file for unemployment benefits under those, all those issues. I saw something, I looked at this, I don't have this up here on the thing, but the interesting thing about partial unemployment benefits is it does not obviate the requirement for the employee to keep looking for a job. So something to keep in mind that if you have an employee who's on reduced schedule, you may want to also put them on job attached, because an employer who intends to bring a worker back within 16 weeks of their last day of work can be on job attached, which means the claimant must be able to work, but they're not required to meet those looking for job. Sorry, Siri is trying to record my talk. Is that they do not have to continue looking for leave, or to work, I'm sorry. A quick one, this has been this March 11th was only 2 weeks ago, and this feels like 100 years ago when the Department of Labor came out with this 4-day paid sick leave. It is for those employees who are currently being tested for COVID-19. It is only those organizations that are in these industries. If you're not in these industries, you don't have, these employees don't have it. But if they are, nursing homes, community living facilities, they are eligible for 4 days of paid sick leave while they're awaiting test results if they're experiencing flu-like symptoms. So the weird requirement is that it says if you give employees already sick leave, and they get 4 or more sick days, you don't have to provide them anymore. So those organizations that are covered only have to provide their own sick leave. They don't have to identify they don't have to give more. Unless the employee has exhausted their sick leave and has flu-like symptoms, then they are entitled to 4 days of sick leave. So if you have an employee who you give 10 days of sick leave to, but for some reason that employee has already exhausted those 10 days of sick leave, they now are entitled to those 4 more days. Only an attorney would think of this question, but what do you do with those employees who have 1, 2, and 3 sick days? They don't have the 4, but they haven't yet exhausted. I think there's an argument they should be getting them. I think their language was too narrow, but that's just my thoughts.
And that, just to be clear, is only for employees who work for those employment categories that you brought up earlier.
Exactly. If
Okay.
you're not in there, you don't have to do this. Let's see. It also talks about FMLA, blah, blah, blah. Yes, they have to be paid at their regular rate. The rule, it says at the bottom here, the rule will only remain in effect for 30 days. That's going to get continued. I can tell that. So those are the leaves. I want to go over really quickly. We get a lot of questions about, like, what do we do with, how do we pay employees? What's the basic breakdown? And those of you who've been to wage and hour talks or been involved with those know that I could not cover the whole thing in 12 minutes, much less 12 hours. But we're going to give a brief background, when you look at how the FLSA, the wage and hour law, and the current Colorado overtime and minimum pay standards, which went into effect March 16th, yes, the rest period obligation as well, and all those issues went into effect March 16th. We're going to break it down into 2 classifications, which are non-exempt and exempt. Non-exempt are basically everybody. Exempt are those employees who are paid on a salary and meet a duty test, one of the duty tests, which are different under federal and state law. Non-exempt employees only have to be paid when they work. So if they're working, they have to be getting paid. The new Colorado law said that could be as short as a minute. I can't believe that. Well, I'm not going to leave that off to the side. But the current comps law did say that could be anything longer than a minute. So if they're working for you, your organization, they have to get paid. If they're not working for you, and this is the key, you don't have to pay them. So if you furlough or you reduce schedule or you eliminate hours from non-exempt employees, they do not have to be paid for the time missed unless they have accrued leave that covers it. Maybe something we previously talked about, PTO leave, they can get access to. You can also deny access to that if you want. You can change your policies to deny access to your provided. You may not be. Let's hold off on that. So just keep that in mind for non-exempt employees. They only have to be paid for their time worked. Exempt employees are different, which is if you have an exempt employee, they get their full salary any work week that they perform work. So if they work on Monday, if you're only, let's say you're gonna open only Mondays and Fridays, they get their full salary. They get, no matter what that is, what that full salary is, to keep them as exempt, they have to get their full salary. Now, if they're missing, if they work on Mondays and then they miss Tuesday, Wednesday, and Thursday because they're sick, then perhaps they would not need to get their full salary if they're not covered by one of the leaves. But initially, they have to get their full salary for any work week in which they work. If you close, which I say at the bottom, if you close on Tuesday, Wednesdays, and Thursdays, they still need to get paid. So a lot of organizations are considering moving their exempt employees to hourly so they can so they don't have to pay the salary, they only then have to pay for hours worked. Because right now, under the salary basis test, you would need to pay them for their salary.
We have had several people asking for clarification on exemptions for 25 employees or less. And how does that fit into the FMLA expansion?
The 25 or less only goes into the job reinstatement. That's the only benefit given to those 25 or less. 50 or less, the law states you may not have to give those paid leaves if your business will not continue if you give those paid leaves. But we need to wait till the regulations come out for those, because we don't know yet how to establish that. Is it just we have to stand up and say, I'll never survive if I have to do this? I don't know. Right now, we're waiting on the DOL regulations. The IRS has promised us that those will be very clear, easy to understand, and who knows. So
We have no idea where our doodles are coming
Yes.
from right now. They're mystery doodles.
my presentation has the virus. We get asked a lot, and I'm not, with the time left, I'm just gonna keep this up there. These will be in the materials. A lot of organizations will say, hey, what do I do? Can I do a leave sharing program? Can employees donate leaves to others? Don't forget, you'll wanna look at, you can just Google Revenue Ruling 9029, but I've got it pretty much identified here. The IRS requires the donating employee, not the employee it's donated to, donating employee to be taxed on the value of the paid leave. The employee donates to another unless the donation is for one of two purposes: medical emergency, declared national disaster. I think we're officially under that. So in that situation, there's no tax burden on the donating employee, but we still must tax the employee that's receiving the donation on the value of those received. So medical emergency, I've got the language up there, but I'm pretty sure we're under both of those. So don't forget, if employees are thinking of doing that, it is not going tax-free to the employee who's receiving it. Couple things to keep in mind. Don't forget that you may be dealing with additional leave. So employees are now thinking they can get additional leave that they were maybe entitled to. If you've got an employee who's earning $15 an hour and they're donating to someone who earns $30 an hour, is it a one-for-one? Do you take into account that issue? Something to consider as an organization. Also, discrimination claims, employees claiming, well, you didn't give it to me because I'm over 40, whatever. So keep track that when you deny those, there's always that chance of discrimination claims. Just a quick announcement. I'm sure most of us saw the announcement by Governor Polis on Sunday that we all should be making efforts to reduce our in-person workforce by 50%. There are certain businesses exempted from that. We'll see that in the next slide. To implement telework options to the greatest extent possible and stagger work schedules, the governor wants us to reduce our in-person workforce by 50%. It's going to take effect March 24th, which is today, and is going to last through April 10th, probably to be extended. These are the businesses that are exempted from that, but everyone else is covered under this. This is in your material, so I'm not going to go through all of those. Don't forget, for those large organizations, those of you with 100 or more employees, that you are required to comply with WARN, which means that if you're going to have a plant closing or mass layoff, which is going to impact 50 or more employees over a 90-day period, that you still have to comply with WARN. And I identify here what mass layoff means and what employment loss means. So if you're going to do that, you still have to give that 60-day notice. There is an exception under WARN that if the reason for the plant closing or mass layoff was due to unforeseeable business circumstances, you don't need to comply with that 60 days notice. Instead, you only need to provide it as much notice as practicable. I can't imagine that this wouldn't fall under the unforeseeable business circumstances, but I wanted to make sure that everyone's keeping track that there are WARN requirements out there. Final topic we're going to go over is the EEOC is reminding everyone, don't forget that with all this going on, we're still required to comply with the Americans with Disabilities Act. We cannot treat those individuals who are disabled, whether or not COVID-19 would be that, I think is going to depend on a case-by-case basis. Still required to do that. The EEOC believes that their rules do not interfere with the CDC guidelines on COVID-19, so we still have to comply with that. Just keep track of those. But the EEOC has updated way back in 2009, in response to the H1N1, I believe it was, they came out with what they call their pandemic publication. They have updated that, so frankly, the advice I was providing 2 weeks ago on how to deal with ADA issues is now moot, because the EEOC has given us many more opportunities as organizations on how to deal with these pandemic issues. So for example, may an ADA, and this is basically everybody, send employees home if they display influenza symptoms during a pandemic. Initially that was yes, initially it was no, you couldn't do it just because someone displayed influenza-like symptoms, you couldn't play doctor with your employees. They have now changed that to say the CDC is allowing us to do that. So an employer, as you see at the bottom, an employer can send home an employee with COVID-19 or associated symptoms, persistent cough, fever, difficulty breathing. We now have the opportunity to do that when recently we were not able to. How much information from an ADA covered, how much information can we request from employees? Well, a couple of weeks ago, it was, unless the employee told us that they were suffering from COVID-19 or had certain symptoms, we really did not have the ability to follow that up. That has changed. So we are allowed to ask questions about that. We are allowed to ask disability-related questions, because the issue here is, if you look at the last line of that answer, which is that because it has been determined that this causes a direct threat, there is an exemption to ADA requirements once a determination is made that there is a direct threat to the employee or to others. And once that happens, basically the ADA it applies, but there are a number of exceptions now because of it, and because of the nature of COVID-19 and its increasing prevalence, it has been deemed a direct threat, and so organizations are allowed to ask questions they previously were not entitled to. So applying this principle, employers may ask employees who report feeling ill or call in sick, they can ask them to determine if they have or may have COVID-19. In essence, you can play doctor with your employees and send them home. Yes?
Does that also apply if you believe one of your employees has been exposed?
Yes, you can ask them questions. So and you can even, the question came up, can you take the employee's temperature? Generally, they're saying, we shouldn't do that. We initially their 2009 publication says, well, only certain organizations should do that. The ADA changed, or the EEOC changed that, and they said, look, because of the community spread of COVID-19, we are going to call it a medical procedure, but nevertheless, employers may measure an employee's body temperature. There's a massive change to the ADA and the EEOC's publication. May they encourage employees to telework? Of course, the answer to that is yes, you can encourage your employees. One question that they just updated was, can you delay the start date of an applicant who has COVID-19 or even symptoms associated with it? Yes, we are permitted as an organization now delay a start date or treat people differently because of COVID-19. Wow, right on time.
Awesome.
Any questions, man, that come in that organizations?
Lots.
There were several questions about how to handle employees who might be abusing the benefits.
Yeah, I will be interested to see how the regulations come at that. Certainly, there's an issue with employees saying, I'm sick, or I've got this going on, or that going on. The level of documentation for the FMLA is pretty substantial. I would expect that this is going to be a reduced expectation of documentation, and that the Department of Labor will expect organizations to place people on conditional paid sick leave or conditional paid child care leave with the expectation that maybe get it down the road, simply because of the medical needs right now. There's just no way to get FMLA certifications signed off in the near future. So I have, John provided as well to reach out to them. We have an admin at BechtelSanto.com for those organizations who are interested to have any follow-up questions with respect. Thank you so much for the opportunity to present, and obviously I would encourage everyone, please stay healthy, and I hope to see you again in the near future.
All right, I want to send a special thank you to Michael for taking time out of his incredibly busy day to keep us all informed in this challenging time. We're grateful, Michael. Thank you.
Thank you.
We will be holding a special webinar for all of our clients to walk through how our software will be able to track and manage the new emergency sick and FMLA requirements due to HR 6201. We'll be sending a link to that webinar to all of our clients and walk you through how the system updates will handle the tracking of this and reporting for future needs. We'll look forward to seeing you all tomorrow. I'm sure that'll be well attended. If you would like to be on our COVID-19 email list, we have pretty good information on a regular basis on this. Just let us know. We don't want to bomb you guys with emails if you don't want them. So if you do want them, let us know. Shoot Man an email, and we'll put you on our mailing list where we keep people updated with that. And in the meantime, stay healthy. Thank you so much from our team here at Autopaychecks HCM and Michael Santo personally for taking the time to help us with this. And please call us if you need any assistance. And we will send the slide deck out to all attendees, which will have Michael and his firm's full attendance information on there. If you have, I'm going to put in a personal plug for Michael. We have been getting his employee newsletter for years, and it's always informative reading, and I would encourage you, if you have not signed up for it, to sign up for that. As an employer, it has been an incredibly valuable piece of information on an ongoing basis. So
I will add a thought to that, which is, it is a quarterly publication. The quarter comes at April 1. We're hoping to be on time this quarter, but with everything going on, that may be interesting. I will also give you a heads up. It will be a short advisory this time. We are only going to cover 2 issues, COVID-19 and the issues with respect to that, and the new Colorado pay standards, which just went into effect March 16th. It's those 2 issues, and outside of that, I didn't think anyone else was going to read anything. So we're just addressing those 2 issues right now.
So with that in mind, if it's going out April 1 or very close to that, you need to sign up really quick to get it. So
yes.
Thank you very much. God bless all of you. Stay healthy, and we'll stay in touch. Thank you.